Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances. Hello. Welcome to another episode of Justice Redefined. I'm Sina Shabestary, partner and criminal defense lawyer at Titan Defence LLP, and I'm joined by
Kabir Sharma, partner and criminal defense lawyer at Titan Defence LLP. You're with us here at Justice Redefined, a podcast where we try to take complex legal ideas and kind of explain them in a simplified manner. Sina, what's our episode about today?
bail.
Excellent. So this is a really important issue that comes up in literally every single criminal file that goes on. And our goal here is to try to maybe explain what bail is, what the legal definition of bail is, and how to increase your chances of getting bail if you're charged with certain offenses. So basically, I'll start. Bail is basically the concept or idea of somebody being released from custody while they're waiting for their matter to finish in court. So what happens is basically everyone is innocent until proven guilty in Canadian court. When they get arrested, the police decide not to release some people from the police station, and they want to or advocate for keeping that person in jail. They say that the person's not going to show up for court, or they say that the person is too dangerous to be released because they're going to commit more crimes. So the lawyer, the defense lawyer, basically says, no, this person can be released into the community if they're properly supervised. So they don't have to wait 6 to 8 months or whatever in jail while they wait for their case to finish, right?
Yeah, and that's exactly the reason why it's such an important element of criminal defense, is because it deals with someone's liberty. Obviously, I think we've talked about this on the podcast before. It's there's a lot of significant consequences that can arise as a result of whether you have to remain in custody or not while you're waiting to have your trial.
And we're coming from a perspective here of, listen, Sina and I have combined probably done like 1,000 bail hearings. I've done probably hundreds, and Sina's done much more than I have, both as private lawyers, meaning clients hire us privately to do bails, and also working as per diem duty counsel, where we're basically in bail court, sometimes doing 4, 5, 6, 7, 8, 9, 10 bails in one day. And so because of the experience that we have doing these kind of bails, not only do we understand intimately how the bail system works, but also intimately understand all the problems with the bail system.
Yeah, of which there are many.
There are many, many problems, and that's something I guess we'll get into at a later point. So just to start off, basically what happens is when somebody is initially arrested or charged with a crime, two things can happen. Either the police can release them on conditions or a promise to appear, which means they don't arrest them and throw them in jail and take them to court to appear in front of a judge. They say, oh, this guy broke a window, he still committed mischief under, and so we'll release him from the roadside or from the police station if he agrees to follow certain conditions.
Yeah, and I think that's actually, for better or for worse, mostly for the better, it's increased significantly since COVID. Police aren't holding as many people as they used to. I think before they would just hold everyone and then draft this, John Grisham novel about why they should remain in custody. And now they're significantly releasing people more from the police station, or sometimes even from the scene of the alleged crime, just on a series of conditions that they will put on them.
Yeah, I've had situations before COVID where, there was a domestic dispute where there may have been a push, and the complainant will go and they'll call the police and say that there was an argument. The police will talk to her. Eventually, she'll say that there's been some contact, but she doesn't want to press charges. Police say it's too late. They take the guy, they arrest him, they bring him to court the next day. The conditions are that he can't talk to her, can't go back to the house. He might wait 2 or 3 days in jail until he gets his bail hearing. He needs to find a surety to release him. And that was a huge problem before, because a lot of these charges, if you look at some of the statistics, something like over 50% of charges that are laid and taken to bail court are withdrawn by the Crown Attorney. And these are statistics that are available on the Ontario Court of Justice website. So keeping that in mind, that's something that us advocates do as defense, something I raise often when I conduct bail hearings. But it's better now that the police now are not as often, as Sina said, taking people to court. They're releasing them on a promise to appear, because most people follow their conditions, right? It's not like most people are in need of supervision. Most people know not to attend or contact this person, right? So I think that's a valuable move. Yeah.
All right. So you made mention of a surety. So just so that our listeners understand what a surety is. A surety is someone who is responsible, whom you respect, whom you'll listen to, etc. And it's someone that may be required at a bail hearing to secure your release. What they often do is they come to court. Sometimes they testify, and they put the court's mind at ease that they can supervise you while you're out in the community. They pretty much become your constructive jailers, if you will. And they pledge some sum of money that's relevant to them, and they are there to help you secure your release. Sureties are oftentimes family members, really good friends that you've known for a long time, and it can't just be any Joe Schmo or a stranger to you. And the surety themselves need to be a person of good character. In other words, they can't have a criminal record, they can't have outstanding charges. Most often, they can't be a surety for anybody else, so that it would potentially interfere with their responsibility with respect to you and your bail. So that's what a surety is.
And people often think that when a surety has to post money to get somebody released, it's not like they have to show up with cash or they have to show up with a check or something like that and give that to the court. The way it works is a surety basically promises to pay the court X amount of money if the accused person breaches their bail. Right? So it's basically something that's done to ensure that the surety is diligent in supervising the accused person. Right? And they do that because the surety can't be charged for not discharging their duty. Right? It's not like if you fail as a surety that they're going to come and arrest you. It depends. Well, it depends on the situation. If you're helping the guy breach, then it's different.
Yeah, exactly.
There's been situations where, I've been in a situation where the person, my client, he gets released on custody in serious charges. The surety's like, yeah, I'll bail him out or supervise him. Picks him up from custody, drives the guy straight to the airport so he can hop on an airplane and bam, dip to Jamaica.
Yeah.
Right? And in that case, well, a surety is, a bit, that's like almost like assisting a breach or being a party to a breach, right?
Yeah. And that's an offense.
Yeah, and in that case, you're going to have to pay all the money and you're going to get charged. But say like if the surety's sleeping at night and someone sneaks out of the window or something like that and you're doing the best that you could, a surety doesn't have to pay necessarily all the money. There's a court hearing that's held and the judge decides how responsible you are. And sometimes you pay 10%, sometimes 50%, sometimes 100%, depending on how good you were at supervising that person.
Right. And I think cash bails, our listeners need to understand that cash bails are really used mostly when the person charged that is not ordinarily a resident of the province. So they are either from another province, they're more than 200 kilometers out from the jurisdiction in which they're charged, or they're from a different country entirely. And then the cash deposit becomes a necessary component of that, so that it gives some assurance to the court that they're going to come back to their court appearances because they're not ordinarily a resident. And with respect to the surety pledge or promise, a question I often get is, what's a good amount? Like, how much do I have to put on the line? And the answer is, it depends. It depends largely on the specific circumstances of the individual who's pledging that amount. We say that the pledge has to bind their conscience. And all that means is that the amount has to be significant enough to them so that they don't say, fuck it, I don't care about losing this money. So if the person I'm supposed to be supervising, my son, my daughter, my husband, whoever, is breaching their bail, I don't care because I only put down $500 as a pledge or a promise, and that's nothing to me. So that's the important aspect that people need to remember, is that the amount that you pledge has to be significant to you. So if you're a millionaire, 10 grand might be insufficient, right? But if you're on some government assistance, for example, $500 might be more than enough to secure your release in terms of a pledge or a promise. So it's always relevant to the person who's pledging it.
And I just want to touch on something that you just said right there, because if you see people who are not ordinarily residents of the country or the province that they're in, they're the ones who are required to provide a cash bail. But think about it this way. Some immigrant or a refugee or someone who literally has nobody in this country comes to this country and gets into some kind of trouble. They have no friends. They have no family. How are they supposed to gather the cash to bail themselves out?
Yeah.
Because it's not like they can go and take out money for themselves. They're in custody.
That's right.
They need to find somebody. And that person has to take that cash and bring it to the court, right? This doesn't happen to most people, but it does happen to some of the most vulnerable people in our society. So just recently, I was in bail court where the person is a refugee claimant from a country in Africa where he was facing significant persecution. And the Crown was offering a $250 cash bail for him, which a regular person would be no issue. But when you have nobody at all in this country,
yeah,
how are you supposed to, even if you have $250, how are you supposed to get that deposited to the court? And that's a bit of a backward system. I guess I don't know. I guess that's up to the Crown, and we'll talk more about the Crown's role in bails now.
I also had recently a client in bail court who was from out of province, and because of the nature of the charges that he had, the police had seized his phone as a result of their investigation, that they were going to keep the phone. And so he was from out of province and he didn't have anybody's number put to memory. So he's like, okay, fine, $1,000 cash. Like, I'm in jail. How can I get my phone? And they're like, no. And he's like, well, what am I going to do? Like, who am I going to call? Like, how am I going to figure out how to get in touch with somebody from back home that can come and satisfy the Crown request to put down $1,000 deposit? So these are the small little intricacies in bail, and really the complexities that are involved. And they're significantly more practical than academic or legal based than the rest of the criminal justice system. And these are the types of problems that we have to help our clients solve when it comes to securing their bail, which is, as we said, very important.
Absolutely. So say you get arrested and the police decide they're not releasing you from the police station. Mm-hmm. So then their obligation then is to bring you before the court within 24 hours.
Yeah.
There's a few reasons for that. One, it's a way to keep the police accountable, to show where somebody is. Because basically what the police have done is legally kidnapped you, right? No, that's what they've done. They've just taken you, arrested you. Nobody knows where you are. So you don't have a lawyer or anything like that.
Yeah.
People be tripping out. You can't have the police just throw someone in jail, keep quiet about it, and have no one know about it.
Yeah.
Right? So there's an obligation on the police to bring that person before the court. So there's at least some oversight on what's going on with respect to that person.
Yeah.
Right? The rule sometimes is broken by the police. There have been cases where sometimes the police, for various reasons, sometimes they're too busy to bring the person, which is also unacceptable. In my mind, the law says it has to be 24 hours. And there's applications you can bring that hold the police accountable if the police take too long to make you appear before a judge or JP.
So I think because of that, also something that people need to know is that bail court in this country runs every day.
365
every
days
day.
A year,
Yeah.
Christmas, New Year's,
And
New Year's Eve.
we call bail court on the days that court is otherwise closed. The acronym is WASH. It's WASH court, which stands for Weekend and Statutory Holiday Court. The practical issue that arises is that police most often do comply with their obligation to bring someone before a justice of the peace or a judge within 24 hours. but it just turns into this symbolic gesture because they don't actually get a chance to run a bail hearing. So for example, let's say you get charged on Friday afternoon and it takes the afternoon for the police to process you and send the proper documents to the Crown in order to bring you before the court. Like, that's not going to happen in Friday afternoon, bottom line. Yeah. So then you go to weekend and statutory holiday court on Saturday, and Saturday morning, even let's say you had a lawyer there and you had family members, sureties, whatever that are there. If your bail hearing is going to be even remotely complex, have even the slightest bit of complexity, they're not going to run your bail hearing.
No.
They're going to say, we don't have enough time. We have a bunch of other people on our docket today. You're sorry. And then you're going to go to Monday morning.
Yeah, you go to Monday morning, and guess what guess what happens on Monday morning? All the other people from the weekend, but that also happened to there in court Monday morning.
Yeah.
So then you're up there in court with 15, 16 other people who are waiting for the bail hearing. And then that's how bail court starts. And the goal of bail court is to wean the list down over the course of the week for the weekend arrest.
Yeah.
Right. And no, it's and one of there's a very important element here that people don't understand. Bail hearings are supposed to be quick. They're supposed to be very efficient.
Yeah.
They're supposed to be very informal. It's supposed to be like bang, bang, bang. Yeah. Can this person be supervised? Yes, no, go ahead. And a big portion of that is the Crown's involvement, right? So what the Crown does is the Crown looks at the package that the police give them. That package consists of like a synopsis, a summary of what happened from the perspective of the police.
Right.
And it's like they also have a bail sheet where the police state the reasons why the person should be detained or sometimes released, or what conditions they should be placed on.
Right.
The Crown can decide whether they consent to the person's release, meaning that the defense lawyer and the Crown jointly go before the judge and say that, hey, this person can be released on these conditions. This person should be released. And those are supposed to happen pretty quickly. Sometimes on the weekend, you'll get your consent release if the Crown agrees on it. However, if the Crown says for whatever reason, no, we don't agree to this person's release or we don't agree to the conditions, that's when the complexity begins. That's when you start to have contested bail hearings, which we'll get into a bit later on. And that's, in my mind and in the mind of many criminal defense lawyers, a reason why our bail courts are so clogged. It's because a lot of people that should be getting out on Crown consents, the Crown's decide to just do what the police say. It's not all of them. Some Crowns are very, very, very fair in their assessment on who should be released or not on bail. Other Crowns are notoriously unreasonable in that regard, and they just detain or they seek to detain everyone.
I think that the element there also is diverting liability, right? They don't want to be responsible for someone's release when they think that there is a risk to the public or there's a risk to a particular alleged victim, something like that, right? And that's their way of diverting liability, is contesting someone's release and saying, we're not consenting to their release. Let the court decide. And in that way, when
it's the judge's fault.
Exactly.
Yeah.
Or the justice of the peace. And that's what it is. That's a big part of it. But I think for a very long time, and still to this date, sometimes it's really lost on the system that, the highest court in our country consistently says that release is the norm and detention is the exception, which means that we hold very highly the sentiment that you're innocent until proven guilty. This isn't a trial. You're just trying to figure out, is the person going to come back to court? Are they going to comply with the conditions of the release? And, is the public going to be okay with them being released? That's it, right?
That's it. Aside
from that, then virtually everyone should be released that isn't already on an existing bail or isn't facing a charge like murder or something like that. That release is the norm. Generally speaking, everyone should get released. But the intricacies that we're talking about is what leads to the system getting backlogged, because the system just simply does not have the resources or the ability to run a contested bail hearing for every single person that gets arrested. It can't happen. And it's a snowball effect, because as soon as you have let's entertain for a moment an unreasonable Crown who's taking the positions on a specific day, and everyone's release is contested, that court is fucked for the day.
Yeah, they're paralyzed.
But that's it. They might get through one thing, if that, and then everybody else is getting adjourned to the next day. And then the next day, there's the stuff from yesterday and the new arrests, and then it just snowballs, and it snowballs.
The thing with the Crown's consenting to release too, it's funny because maybe they have some information that I'm not aware of or whatever, but I've had situations where, somebody gets arrested with a loaded gun and go to court the next day, present a plan, and the Crown will release that person on consent.
Right.
And then you have a situation where the guy has no criminal record and he gets into a relatively minor altercation or fight with somebody like on the street, and the Crown is vigorously contesting their release and wants to get them detained. And there's supposed to be some rules and policies that are meant to be followed, but it's very discretionary. And for the most part, I feel, when the Crown wants to detain somebody, it's for a decent reason. The person has a nasty record, charges are really serious, right? But you also quite often get, some situations where everyone is just rolling their eyes saying, what's going on here today?
Yeah. So, I think where defense lawyers come in, for example, right, there's many ways that you can be taken into custody. So either, police are present or called to the scene of the alleged crime, or there is an outstanding warrant for your arrest based on an allegation that's been made against you, right?
Yeah.
When the police are called to the scene, that's it. You're there, you're getting arrested, you're getting taken to the station, or seldom they might release you roadside or from the scene, or they'll take you to the station, process you, release you there, or keep you, and then you go to bail court. But if there's a warrant out for your arrest, right, what is it that a lawyer can do for you which could try to make sure that this process goes as smoothly as possible and there is as little interruption to your life as the alleged accused in terms of the bail hearing?
Like what a lawyer can do? You're asking me?
Yeah.
Like what I typically do is I make sure that I arrange or have a discussion with the police officer, right? If there's an arrest warrant out and they're looking for my client, I say, listen, firstly, what I do is I say, if there's a warrant out, sometimes the warrant can be endorsed for the person to be released. Sometimes the person has to be taken to a JP. If it's an unendorsed warrant, there's
right.
It's a complicated, it's more of a police issue than a criminal issue realistically.
Right.
So, I'll speak to the cop and I'll be like, listen, this is the situation. Are you going to release this person from the station? If they say yes, easy peasy. Sometimes I write an email to confirm that with the cop, that's what they're doing. Sometimes they say, no, we're going to take them in front of the JP. If they're taking them in front of the JP and taking them to the court, I ask the cop specifically, what's your position on this person? Do you care if he's detained or not? Sometimes based on the charges what the cop is going to say.
Right.
But other times it's a bit like, what's going to happen here, right? And I'll speak to the cop and I'll convince the cop, over several maybe phone calls that number one, I'm not available until this day to do the bail hearing, so he's not going to surrender himself until this day. Right? Cops are generally, they don't like it, but they have to be okay with it. Because what I say is what I'm doing is I'm making everybody safer by arranging this person's surrender when they come into the police station. Right? If there's a warrant out for the person's arrest, you can go out and look for the guy.
Exactly.
For sure. But do you want to put your officer at risk and my client at risk? Who knows what's going to happen? There's going to be a fight. Someone's going to get hurt. It doesn't make any sense. Right? Say I'm not available the day that the officer wants him to come in. I'll say, I'm available 2 days from now for a bail hearing. Right? So if you're going to release him from the station, I'll have him come in now. But if you want to keep him for a bail hearing, then you're going to have to wait a couple of days. And sometimes I'll speak with them do you really need to keep this guy? What's your position on releasing this person? Sometimes I can get them to agree that I'm just going to tell the Crown to release this person. Sometimes they're going to say something like speak to the Crown. So that's what I do when somebody has an arrest warrant.
Yeah, and more often than not, I think they're pretty reasonable with me. It really largely depends on, again, as you've said, the circumstance of the alleged offender. Like,
Yeah.
what's their criminal record? What's the charge? Things like that. If it's a murder, they're not waiting for you, man.
Yeah.
They're
knocking,
looking.
they're kicking your grandma's door down,
Yeah, that's
your uncle's
it.
door,
Exactly.
your son, daughter's door. They don't give a shit.
But otherwise, they'll cooperate and they're reasonable. And you say like, I don't want my client to sit in custody for longer than he or she has to.
Yeah.
The charges are not the most serious, or they are, but I have a good plan that I'm going to present to the Crown if they're going to take the police have the position that they're going to take him for bail anyway. And you say, okay, so can you tell me what time the shift changes, for example, and who my client needs to come and speak to?
Yeah.
And then you tell the client the specific things that they need to do. Get a ride there or park your car in the parking lot. Make sure that you're not wearing shoes with laces because they're going to take them away from you. Make sure you don't have your electronic devices because they're going to take them away from you. Just, go there in comfortable clothes, warm, comfortable clothes. Surrender yourself. Take your ID with you. And this is the time that you should go in, so you're not spending any unnecessary time sitting in custody. So, go in at 7 p.m., you'll get processed, and for sure by the next morning, you're going to be in bail court.
Yeah.
Or
7 a.m., you mean? Or 7 p.m.?
No, I mean to surrender,
surrender.
At 7, like in the evening, if they give you that opportunity, so that gives them enough time to get your paperwork done and have you be in bail court present the following morning, first thing.
I see. Yeah, that makes sense. So basically, if you get taken to court, you got to have a bail hearing, right?
Yeah.
So a bail hearing is basically an argument between the Crown and the defense as to should this person be released or not. So the way that you conduct those arguments is by calling evidence, right? Because contrary to popular belief, what a lawyer says in court, unless it's backed up by some evidence that's been either agreed upon by the parties or tested, it doesn't mean shit, right? If I go up there and say, oh, my client has a job, my client's going to listen, my client's going to do this, my client's going to do that, the judge is going to, or the JP is going to say, okay, where did that come from? You're just saying it.
Right.
Counsel. So what you need to do, especially in a bail that require one of those more complex bails, is you have to call your surety to come and testify. So your surety comes and testifies, and your surety is the one that says, I've known this person for this long, this person's employed, I'm going to make sure that I look after this person can live with me.
They'll listen to me, they'll respect me.
They'll respect me. I have enough money to put up in case he breaches. He's not going to breach. If he breaches, I'm calling the police.
Yeah.
I'm going to be aware of all of his court dates. So that's the kind of evidence that the defense lawyer gets out during a bail hearing. And then after that, what happens next?
Then you make submissions. You make submissions on bail and as to whether...
After the Crown cross-examines.
Yeah, of course.
So,
well, it depends. If we're talking about... I guess what you're talking about right now is a contested bail hearing.
Yes.
And then, at a contested bail hearing, the Crown, depending on really how contested it is, might go ham cross-examining the sureties.
Yeah.
And I think that's one of the things, especially with more serious cases. Sometimes I think to myself, I'm like... why are you berating this poor surety, man? They're here as a friend of the court. Yeah. They're here to assist somebody. They're not here to. They're not the ones that are charged.
Yeah, no.
Leave them alone.
And I've had, man, some absolutely crazy situations where I'll call a surety to come and testify on behalf of my client, and the surety would have a parking ticket from several years ago that they didn't pay. Or they'll have maybe a speeding ticket. Or one time the police came to their door because someone said that they heard noises in the house. And man, the Crown would be like, you don't cooperate with the police because you didn't open the door to the police. You didn't pay your ticket. You knew you had to pay this ticket. There was a date on it. You don't follow the law. And they just straight smack talking your surety the entire time.
Digging.
They're digging. They're waiting for the surety to get nervous and make a mistake. We prepare all of our sureties for any situation like that. And let me tell you, man, most JPs and judges hate that shit.
Absolutely. Yeah.
It just goes nowhere at all. It wastes so much time.
Yeah.
Everybody's rolling their eyes. Yeah. What the fuck does paying a parking ticket have to do with your ability to supervise someone?
I recently had an issue on a bail hearing. So the Crown was actually willing to consent to my client's release. It was a possession of a firearm case. Okay, he had a record previously, non-related. It wasn't for a firearm, and his girlfriend was pregnant with his baby, and I was proposing his girlfriend as the surety, and she was totally responsible, no criminal record, employed, a good, outstanding citizen of the community,
Yeah.
And the Crown dug up a prior domestic that my client had, which was withdrawn as against a completely different woman, different partner. And they're like, no, a domestic partner is not an appropriate surety in this case. And I'm like, why? What's the problem here? The charges were withdrawn. And they're like, the charges were withdrawn because the complainant never showed up to the trial. I'm like, what's the evidentiary value of that? Why does it matter? Does this mean that anytime someone is charged with a domestic and their trial doesn't get through and the charges are withdrawn, they can never have a domestic partner be their surety in the future?
What kind of precedent is that? It makes absolutely no sense. I mean, they'll reach for any argument that they can to justify their position. And you'd be surprised. Sometimes, this is the thing with, throwing shit at the wall until the something sticks approach.
Yeah.
Because if you do it long enough and you have an entire organization doing it for long enough, eventually the shit's going to start to stick to the wall.
Right.
And who knows, man? You bring that argument enough and you might find a JP that actually thinks that's a valid argument to bring, right? That's the scary part.
Yeah. And the shitty thing about bail is that you get one shot, man.
Yeah.
That's it. You fuck up that bail hearing and there's a detention order, that's it. The next step is a bail review, which is, it's lengthy, it's costly.
Yeah, you're basically appealing your bail.
Yeah.
You have to say that there's a mistake that was made.
A legal
error, or that your situation has changed so dramatically that you deserve a new bail hearing.
Yeah.
That's basically it. But you know what? One of the benefits of COVID is now for bail hearings that thank everyone and the pandemic was a very bad thing.
Of course.
I'm not pro-pandemic at all. All right. But what I'm saying is that now bail court is virtual.
Yeah.
And you really have to have been there prior, before bail was virtual, to realize how cumbersome the bail process was on somebody's life. Because, man, before you would show up to court, your sureties would have to take time off work. Sometimes you have 2, sometimes 3 sureties. They would have to show up to court, and then you would be sitting and waiting. Hopefully you get a shot at bail if you get reached that day.
And you don't get reached?
And you don't get reached, and guess what? Everyone has to come the next day.
Yeah.
As a lawyer, you can't ask for more money for that. Some lawyers do. I don't do that. Right? And guess what? Your surety's got to take time off work again.
Yeah.
Sometimes they would do that for a week straight until you got a shot.
Yeah.
And that was absolutely awful, especially if, you live downtown or you live uptown somewhere in Vaughan and you have to commute to Old City Hall downtown for a bail hearing for a week straight.
Yeah.
Like that, by the time you're there after 4 days, mentally you're drained. Because remember, you're not there and you find out that you're not going ahead. You got to sit there and wait for 6 or 7 hours.
It's the hurry up and wait system.
Yeah, hurry up and wait, right? Now with Zoom court, the benefit is that, we'll know if the bail is going ahead and we can tell the sureties to just log on right away. And then bang, the sureties will log on and we can get our bail going. Right?
And it's because there's so many moving parts with bail. The police have to do the paperwork, send it to the Crown. The Crown has to look at it, take a position. Is it a consent? Is it a release? Bring the person in front of the court. Are we calling evidence? Are we not calling evidence? Then there's submissions. There's a lot of different stakeholders have to come together to make a bail hearing work out. And that's why it was so fucked up before. And so, the new system has helped a lot with respect to somewhat making sure that bails are running a little bit smoother because of just simply eliminating the logistics component of a bail hearing, like getting everyone physically in one place.
That saves a lot of time. It saves a lot of headache. Go ahead.
So, and the other thing that's happening with Toronto, I think by the time this podcast will be out, the new courthouse will be open. That's the courthouse that's located just north of 361 University.
I think it's 10 Armory is the address.
That's
I
it.
believe,
yeah,
right?
10 or 11 Armory. I can't remember it.
Yeah.
And that's going to be all the Toronto courthouses. And 2201 Finch is going to become the dedicated bail court.
Yeah.
And they, as I understand it, they're still keeping the system of doing bails virtually. I'm not sure if that's actually true for the accused individuals, whether they're going to be physically taken there or they're going to be at the police station, or, well, if they're in jail, they're in jail. I don't know if they're going to be physically brought to that location.
Yeah.
But sureties will have the option to either attend in person or virtually. And I think the same will likely be true for counsel as well.
And I hope that, there's some that we hang on to this system, because I think that this is a system that literally everybody prefers. I think the only difficulty in this system is the institutions, the jails.
Yeah.
Because the problem is that the jails don't have enough video booths to have multiple people going into courts at the same time. And the jails are so big that to get someone to appear, like the guard has to walk a kilometer through all the hallways of the institution, get someone, and then walk them all the way back. And if they're busy doing a bunch of other things, it can take sometimes 20, 30 minutes to get a client to even show up. So that's a bit of an issue, but maybe bringing people in person is going to solve that. I don't know.
And, that even happens at because of all the moving parts we're talking about, that sometimes happens at the division too.
Yeah.
They're like, oh, bring the person to the screen. We want to deal with their matter. And they're like, oh, they're talking to duty counsel or their lawyer or something. And they're taking up the booth, or somebody else is doing that.
So the thing with bail hearings too is usually, how Sina says release is the cardinal rule. When it comes to bail hearings, release should be the norm. There's some charges and some situations where release is still the cardinal rule. However, usually it's the Crown that has to argue to keep you in jail. Mm-hmm. So they get up and say that this person should stay in jail. But in some situations, basically your detention is somewhat automatic, and you have to argue that you should be released. Right.
Yeah.
And those are called reverse onus bails. And there's a few different types. The first one is if you're already on bail.
Yeah.
Right. And you've already been given your shot and you're out, and then you breach that bail and you come before the court. They're going to say you've already been released. Now you explain to us why you should be released.
Right. Another one is if this was actually fairly recent, which is if you're charged with a second domestic, you're now in a reverse onus as well.
I think that's also in a certain time period, I think.
Yeah.
Within 10 years or something like that? Is
something
that
like that. I can't remember the exact timing, but it's second domestic, then it's a reverse onus.
It's also some more serious offenses too. Like gun robbery.
Yeah.
It's always reverse onus.
Yeah. And then you have some offenses like 469 offenses that goes even further. Like if you're charged with murder.
Terrorism or something.
Yeah. Then you actually get an automatic detention order, and then you have to seek bail in Superior Court, which is a higher court than you would normally go for a bail hearing. Yeah.
And so those kind of charges do increase the complexity of your hearing. We get a lot of people here who are charged with serious offenses. Another one is possession for the purpose of trafficking, those types of offenses. Mm-hmm. The court thinks that, people make so much money selling drugs that they should establish themselves why they should be released. But there's a big problem there because, if a cop charges you P for 3 grams of coke, are you some big shot drug dealer that is making so much money that you need to establish that you should be released? Because that doesn't really make sense, right?
And that's what the lawyer is supposed to do. So the P for P is possession for the purpose of trafficking. It depends on the substance, but you could potentially argue that 3 grams of any substance could be for personal use and not for the purpose of trafficking. Let's just entertain that without making it more complicated. And that's what the lawyer is there to do. Yeah. And one thing that I think, the court has also recognized is that, just like you said previously, like a synopsis or an allegation is something that the police have put together, and it's not evidence. Right. No. They're taking that summary from the evidence that they're going to later disclose. Right. And more often than not, what happens is that that's all that you have. And you don't know what evidence they have that they've based that summary off of. So the court, in recognition of that, has said that the informal and expeditious nature of a bail hearing makes the Crown's case artificially strong, which means that, and the strength of the Crown's case is a relevant consideration for the court as to whether you should be released or not. And basically the court is recognizing that, exactly as you said previously with respect to the statistics, a lot of cases fall apart.
Yeah, they do.
Once you get it later on to a lawyer's hands, and then you get disclosure, you go to court, they completely fall apart because it's allegations, and that's the point of the process. So the courts need to, also be sensitive to that cases fall apart.
And so let me tell you something about allegations, okay? Man, this situation probably infuriated me maybe more than any other situation. I wish I could have done something more about it, but I couldn't have. And it was a bail hearing, and my client was arrested for domestic. The accusation was that he slapped his domestic partner in the face. And in the synopsis, it said it was caught on a gas station video camera. And it was caught on video. It was clear. He's easily identifiable. This is the guy that did it. I'm like, man, this is kind of a strong case. The Crown was like, oh, it's on video. It's a strong case. Get the guy out on bail. Pretty serious conditions. I keep asking for the video. Where's the video? And remember, a police officer is the one that's drafting this. It's not a Crown. So the police officer is the one that's drafting this. I'm like, where's the video? Where's the video? Where's the video? Months go by. There's no video. You get a response that there was never any video to begin with. So whoever wrote that synopsis flat out lied about there being a video that showed this happening. And rather than me getting to expose the Crown and it causing a big stink about it, the Crown just pulled the case.
Yeah.
Couldn't even do anything about it.
Yeah.
They pull it secretly, quietly, so no one hears about it. And the cop doesn't look stupid or get in trouble about it. And that's it. Poof, be gone.
And
that really... That pissed me off for a long time. I still think about that to this day sometimes.
That's the difficult bit, is that when you lose your liberty in the court, the Supreme Court actually says this: liberty lost is never again regained.
Yeah.
That's it. You can't give somebody's time back.
No.
And the system is not designed for anybody to easily be able to seek reparations for having been charged erroneously or by mistake or kept in jail for a long period of time. I had a client one time who had a solid alibi, and the duty counsel ran his bail hearing for him because I was unavailable.
Yeah.
And his girlfriend, who was being proposed as a surety, was his alibi. Okay?
Yeah.
And she was unequivocal about where he was, what had happened, etc. And the JP ended up detaining this guy despite her testimony, and that's the Justice of the Peace. And it took me months to tell the Crown. I immediately put them on notice. I said, this is his alibi. This is where he's saying he was. She has evidence that can potentially prove this. Go investigate. Send the police to go and investigate this. You have an obligation to do that. They dragged this kid through the mud, bro. They dragged him through the mud. He ended up staying in custody for 5 or 6 months before they ended up pulling the charges.
Brutal.
What
did he get for that? Nothing.
Nothing.
Zip nada.
Nothing. He lost his job and he has to start from scratch again. So that's the really fucked up bit about bail. And one thing I want to discuss right now is that we've talked about the bail process, what it's like, etc., but we haven't really talked about what conditions you can expect when you're put out on bail and the problems that arise from specific bail conditions.
Absolutely. Good point.
So, like we've said, the conditions of bail are supposed to be tailored such that they satisfy the 3 grounds that are before the court. Meaning that you come back to court, that you don't commit any further offenses, and that the public wouldn't be outraged if you were released, okay? So what are some of the conditions that could be placed on you on bail, Kabir?
You will almost, in my experience, always get a no weapons condition. Mm-hmm. No matter what you do, no matter a weapon was involved or not.
Yeah.
That's always coming.
Yeah.
If it's a domestic situation, you're going to get a do not contact your wife or domestic partner, whoever the person may be.
Yeah. Which means that you can't go back home.
Can't go back home, right? Say, your partner is dependent on you financially, emotionally. Even though they wish to proceed with the charges, they still need money to pay the rent or whatever. And, sometimes when people have those types of conditions placed on them, their entire lives will fall apart.
Absolutely. For sure.
Right? They'll get divorced. People will go in homeless shelters. They'll go broke.
Mm-hmm.
Kids will ruin, or parents' relationships with their kids will get ruined forever.
Yeah.
And this is for two people that want to communicate with each other again.
Yeah.
Right?
Yeah.
They both want to. It's the system that's telling them, no, you can't. So that's, like, for example, one of the conditions that can be imposed.
And there's two things I think that's oftentimes lost on the courts and the crowns and judges, justice of the peace, etc., which is that, number one, there has to be a nexus or a correlation between the condition you're putting on someone and the allegations.
Yeah.
If it's a domestic, you can't be like no driving, put a driving prohibition on someone. That makes no fucking sense, right?
Yeah.
And number two, because of the presumption of innocence, you can't punish someone with bail. They're not supposed to be punitive measures when you're considering the conditions of bail. But oftentimes that's the effect. And the problem is, like, one of the things that you said is reverse onus. You have to satisfy the court why you should be released if you are on an existing bail. Well, if you were going for bail and you agreed to all the conditions that the Crown wanted to secure your release in the first place, because everyone wants to get out of jail. Who the fuck doesn't, right?
Yeah.
And then you have all of these unreasonable conditions that you were never able to comply with. And then you get slapped with a breach because invariably you come and you breach your bail. Then that's the snowball effect that fucks things up as well.
That's what sucks you into the system.
Exactly. And one perfect example of that is that you have a drug user. And this drug user gets caught for simple possession, whether it's heroin, meth, crack, whatever it is, cocaine, doesn't matter. Okay?
Yeah.
And a condition of the bail becomes, do not possess any illicit substances. What do you think? You've just all of a sudden fixed the addiction problem?
Yeah, no.
Like the court telling you don't do that? Oh, no problem.
Yeah, I'm going to get out here and I'm going to quit. I'm doing heroin for 19 years. I'm going to stop.
Exactly.
Some stranger sitting on a bench.
You're
to do
setting that person up for failure, dude.
Yeah,
they're never going to be able to comply with that. Not to mention that possessing illicit substances is an illegal act already.
Yeah.
Why the fuck?
Double punishing them.
Double punishing.
Yeah.
They're just going to now get two charges. One for breaching bail and one for possessing an illicit substance under the Controlled Drugs and Substances Act. Right?
Absolutely. And, okay, listen. So before we finish, there's, I think, one important thing that we should talk about, and something that you brought up that I think our listeners need to know about is why people accept all of these crazy conditions to begin with. Right? And what happens is say the Crown consents to release, but they say that they want all of these crazy and reasonable conditions on the bail, right? They say, if you accept these crazy and reasonable conditions, you'll get out today.
Yeah.
However, if you want to contest them, our courts are so busy, you have to wait 4 days for a bail hearing.
Yeah.
Who in their right mind is going to sit and wait 4 days in jail to argue about a couple of conditions here and there?
Oh, I'm very principled.
Yeah. No one's going to do that, man. Let's be realistic. Think about it. 2 days away from your job will get 99% of people fired.
Yeah.
Right? Absolutely.
Yeah.
Without any explanation or anything like that. And the JPs are supposed to do something. It's codified now in the criminal code. It's the principle of review.
Yeah.
So the Supreme Court of Canada understands that sometimes people accept unreasonable consent releases because they have to get out of jail.
Yeah.
So even if the Crown and the defense consent, it's up to the JP to look at these conditions and assess whether or not they're reasonable. And that does not happen nearly as often as it should. Some JPs are aggressive with their principle of review.
Yeah.
Right? They will slap defense counsel for saying, how did you agree to this? Right? And everyone has their reasons as to do why they need to do whatever they need to do.
Yeah.
Other JPs, even if I say to them, one of the things I say oftentimes when I'm duty counsel is the duty counsel has consented to this because he can't wait for a contested hearing. However, keep in mind, you must apply the principle of review to this consent release to see if the conditions are reasonable and the bail is constitutional.
Yeah.
And they say, oh, no, it was agreed to. We agreed to this. The JP can't usurp it, whatever. And it causes a whole problem. But
which is nonsense because they're the gatekeeper to the conditions.
Yeah.
Right? They're supposed to decide what's reasonable and what's not reasonable.
Absolutely. Right? So I guess, is there anything else you want to add before we end this?
No, I'll just point out that a JP is a justice of the peace.
Yeah.
And a justice of the peace is not required to have a legal background. So they don't have to be lawyers. Sometimes they are.
And that's a good thing too in a lot of cases.
Right.
Because, members of the community should be the people who are deciding whether or not
somebody released.
Should be released.
Sure.
Yeah.
But just practically speaking, there was a pilot program that they did at College Park where it was judges who presided over bail hearings. And because of the academic component of it, and because of the consistent and persistent language that the higher courts, especially the Supreme Court of Canada, used with respect to bail, a lot more would happen in bail court. Judges would just bang out bail hearings. Be like, what are we doing here?
Yeah,
this is a theft under. I don't need your stupid submissions.
Did they steal the crown jewels? I remember one time. I had a client that stole like a sweater from Old Navy, and they wanted to put her on a bail. It happened at Scarborough Town Center, and they wanted to ban her from all of Scarborough Town Center, and they wanted to put her on this crazy bail. And the judge turns and looks at the crown and says, "Crown, did she steal the crown jewels of England? Why can't she go into Scarborough Town Center to go do the rest of her shopping?
Yeah.
Why can't she, just be forbidden from attending Old Navy?"
The good old banishment clause.
Yeah, that's another
on bail.
They love that one up north.
Oh yeah, get out of our town.
You get arrested in Thunder Bay. One of the conditions of bail is you don't come back. It's a classic one. But yeah, I think that's enough for this episode, Sina. Unless you have anything else to add.
I just want to say that if you can afford a private lawyer for your bail, of course that's always beneficial, especially if your charge is more serious. Because they're able to focus on your specific matter, right?
Yeah.
But if you can't, obviously, duty counsel does incredible work.
Phenomenal.
And their only limitation is the resources that they have. They have to deal with dozens of bail hearings in a day. And even though it's a team of duty counsel working on it, they do an exceptional job to the extent that they can.
They're the ones that keep the bail courts running.
Absolutely. And that's the difference, right?
Yeah.
You have a group of people dealing with every single bail that's coming into the system rather than one defense lawyer who's retained privately or whatever else. Who can spend the time, right? Yeah. So if you can, get ahead of it. Get ahead of it and get a lawyer to come and help you with your bail.
Absolutely. So thank you very much, everyone, for listening today. If you have any questions, don't be afraid to give us a shout. Peace.
Later.